Good
Good morning,
morning,
sir.
everyone. Good morning, everyone. On behalf of IPR Cell, Bharati Vidyapeeth Dr. Patangrao Kadam Mahavidyalaya Sangli, I warmly welcome you all for today's function on intellectual property rights. For today's function, we have Chairperson, Honorable Principal Dr. D.G. Kanse sir. We have eminent guest, Dr. Ajay Thakur sir. Now I request Honorable Principal D.G. Kanse sir to give welcome and forward of today's function. Honorable Principal D.G. Kanse sir.
Good morning, one and all. The chief guest of the today's webinar on intellectual property rights, Honorable Dr. Ajay Thakur sir, in charge of the Arts and Commerce faculty, Mr. T.R. Sawan sir, convener of this IPR cell of our college, Dr. B.B. Balla sir, coordinator of IQAC of our college, Dr. Suple sir, head of the Department of Microbiology Department, Mrs. Bhavikatti Madam, all my faculty members, dear research students, students of the UG and PG classes of our college, and friends. As the principal of this college, it is my great honor and privilege to welcome all of you to Bharati Vidyapeeth Dr. Patangrao Kadam Mahavidyalaya Sangli. Friends, we are extremely happy to have the chief guest of the today's webinar, Honorable Dr. Ajay Thakur sir. He is a Assistant Controller of Patents and Design, Government of India. Mumbai. He has vast experience of the academic as well as administrative positions. I take this opportunity to welcome Honorable Dr. Thakur sir on this platform, online platform, with great respect. I welcome all the faculty members, all the participants, all the research students, and the students of UG and PG classes of our college. Friends, let me express briefly about the Bharati Vidyapeeth. All of you know that the Bharati Vidyapeeth was established on 10th May 1964 by Honorable Dr. Patangrao Kadam Sahib with a wider objective of social transformation through dynamic education. It was a small beginning by conducting the examinations of the tough subjects like English and mathematics for school-going children. Slowly, it gathered momentum and turned into higher education in 1978. In 1978, Bharati Vidyapeeth started 3 higher education colleges. One of them, Yeshwantrao Mohite College of Arts, Science and Commerce College, Pune, New Law College, Pune, then Institute of Management and Research, which is located in Pune. Today, Bharati Vidyapeeth has more than 180 educational units catering for the educational needs of the students from kindergarten to postgraduate in almost all kinds of the disciplines, including research institutes. The dream of our beloved founder, Honorable Dr. Patangrao Kadam Sahib, came into existence on 26 April 1996 when the University Grants Commission gave the status of the university to Bharati Vidyapeeth. All this is due to the tireless efforts of the Honorable Dr. Patangraoji Kadam Sahib, who is the founder and lifetime chancellor of our multi-faculty and multi-campus university. This is also possible due to our present chancellor, Honorable Dr. Shivajirao Kadam sir, and the secretary, Honorable Dr. Vishwajit Kadam sir. The main focus of the Bharati Vidyapeeth and Bharati Vidyapeeth deemed to be university is the all-round development of the students and their academic excellence. Our college, Dr. Patangrao Kadam Mahavidyalaya, is one of the branch of the Bharati Vidyapeeth and was established in 1985. It is situated on the holy bank of the Krishna River and the close vicinity of the famous Sangli city. Our college is affiliated to Shivaji University, Kolhapur, and has been recently awarded in the third cycle with B++ grade with 2.96 CGPA from National Assessment and Accreditation Council. It has been also honored with a special award for NSS by the government of Maharashtra. Besides, Shivaji University has given the status of lead college to our college. We have PhD programs in chemistry, microbiology, Hindi. University Grants Commission has sanctioned various career-oriented courses to our college under community college scheme. Our college has also received funding from Department of Science and Technology under funds from Improvement of Science and Technology scheme. Some of our students of our college are the rank holders at the examinations of Shivaji University, Kolhapur. Some others have won the number of medals at national and international levels by participating in sports competitions. Friends, I would like to share with you that every year our college organizes various knowledge events and related activities. Even though during the lockdown period of COVID-19 pandemic, we have successfully organized more than 12 webinars, training programs, and faculty development programs for teaching and non-teaching faculties. We have also conducted 7 online teachers training workshops on the new change syllabus of the various subjects sponsored by Shivaji University, Kolhapur. Today's webinar is a part of the different activities. We are conducting it on online mode. I hope this webinar will provide a platform for the discussion on the intellectual property rights. Intellectual property rights, in short IPR, are the exclusive rights granted to the inventor to use his her invention or creation for a set of time period. An industrial patent helps the government to attract international investors to invest in India, and it always results in acceleration of economy of the nation. The intellectual property index status of India shows that there is a positive and strong relationship between IP index and GDP of the country. In 2008, the India had 11,546 patents, and on that time, the GDP was 4,533 billion US dollars. In 2017, almost after 10 years later, the number of patents applications reached to 27,985 with concurrent increase in GDP of 8,606 billion US dollars. Share of this patent in this field of science and technology in India is about 16.34%. In pharma, it is 6.3% and 7.33 in semiconductor industry and so on. Today's webinar is aimed to shoulder our responsibility in the nation's growth. Once again, I welcome on this online platform to all of you on behalf of Bharati Vidyapeeth and Bharati Vidyapeeth Dr. Patangrao Kadam Mahavidyalaya Sangli. Thank you once again. Over to Dhanavade sir.
Thank you, sir, for your precious words and kind encouragement to conduct this program. Now I request convener of today's function, Dr. B.B. Balla sir, to introduce our eminent speaker, Dr. Ajay Thakur sir. Dr. B.B. Balla sir.
Thank you, Dhanavade sir. Am I audible, Dhanavade sir? Dhanavade sir, am I audible?
Yes, you are audible.
Yes. Good morning to all dignitaries and delegates with immense exultation. I feel privileged to extend my warm welcome to today's guest, Honorable Dr. Ajay Thakur sir, and all attendees of the webinar. I am profoundly elated to take an opportunity to introduce our chief guest, Dr. Ajay Thakur sir. Sir, you hardly need any introduction. You have made all of us proud of your distinguished work in numerous capacities. Dr. Ajay Thakur is presently working as Assistant Controller of Patents and Designs at Government of India, Patent Office, Mumbai. His educational qualification is astonishing and almost touched every diverse field of knowledge. He completed his MSc in Biochemistry from University of Pune. Later, he completed Masters in Management Sciences with concurrent diploma in Business Management from University of Pune. He completed his MPhil and PhD in Marketing Management. In 2008, he completed LLB from University of Mumbai. I am very proud to say that he is a recipient of Dr. Babasaheb Ambedkar Centenary Award for securing highest marks in Mumbai University. He also completed a LLM and various certificate courses run by WIPO, World Intellectual Property Organization, Geneva. Before his career in intellectual property, he worked as Senior Scientific Officer in Hindustan Antibiotics, Pune. He has thorough experience of penicillin fermentation, streptomycin fermentation, pharmacin fermentation, enzyme production, sample testing, raw material testing, final product analysis, and his experience helped a lot to Patent Office for resolving critical issues during examinations and grant of patents. He also worked on deputation with RBG Life Sciences. Since 2003, he is working as Assistant Controller of Patents and Designs in Patent Office, Mumbai. And his duties includes granting or refusing of patent applications forwarded by examiners, conduction of patent hearings, analysis of techno-legal examination reports submitted by patent examiners, and all other duties to fulfill the obligations of Patent Act and subsequent amendments. He also extended his participation in training activities organized by USPTO, United States Patent and Trademark Office. Just for the reference of audience, I am giving figures of patent applications filed in 2020. In China, it was 15 lakhs. In United States, it was 5,97,172. In Japan, 2,88,472. In South Korea, 2,26,759. While in India, the figure was only 56,771. Knowing his responsibilities, Dr. Ajay Thakur sir conducted more than 1,000 patent awareness programs in various universities, colleges, industries, and organizations. Beyond his duties, he is trying hard to increase the share of India in IPR. Sir, all of we are proud of you. On behalf of management, I thank Dr. Ajay Thakur sir for providing his gracious presence to join today's webinar. Now I hand over the session to Dr. Dhanawade sir. Thank you. Thank you very much, sir. Yeah. Dhanawade sir.
Thank you, sir, for giving a nice introduction about today's guest. Now I request eminent speaker of today's webinar, Dr. Ajay Thakur sir, to proceed with his talk. Thank you. Ajay Thakur sir.
Good morning, everybody. Thank you, Dr. Kanse sir, Honorable Principal of Bharati Vidyapit, Patangrao Kadam College, Mahavidyalay. Of course, Dr. Ballal sir, the convener of IPR cell of this college, Dr. Dhanawade, all the professors or party professors, then all faculty members, all research students, and of course all the students who are present here to attend this session. First of all, I am very much thankful for inviting me for this occasion on the presentation of IPR and different intellectual property laws. I may not be the so good orator, but I'll try my level best to convince, or I'll try my level best to suffice your requirement as per the requirement is made with regard to intellectual property and patent laws. So first, I am very much thankful to everybody, and now I will start with my session as per the program which was given to me. So I'll start with my presentation relating to intellectual property rights, and of course we are present or that are existent, and we will also see how patent office examines your patent applications and what sort of difficulties you are facing. I will be happy to address them if I come across such kind of difficulties. So let's not waste some time, and we will start with the presentation on what is related to intellectual property and what are the things that we are going to discuss in today's session.
Hello, sir.
Yes.
Click on presentation, present.
Yeah.
Then okay.
Now is it visible and audible also?
Yes, is it audible, sir? But present, we have to present, sir.
But it is visible.
Yes, it is audible only.
It is not visible.
Not. Sir.
Okay. Now is it visible?
Hello.
Yes.
Sir, what to do? First, you will open your presentation in the backside.
Right. I'd open that. Just
okay. So right now you will click on the present.
Okay.
After you will select share screen.
Right.
After you will click on that window. Entire screen च्या खाली जी तुम्हाला will see on the below the entire.
Now it is there.
Wait, we will check. Yes, sir. Yes. So make it full screen.
Okay.
Okay,
now
sir.
It is visible.
Yes, sir. Yes, it will working.
Okay. So welcome to all the delegates there. So we will start with first of all, let me make it very clear. As per Dr. Kanse has pointed out that intellectual property plays a very important role. So basically, intellectual property rights, when we talk of IPR, there is a misconception that intellectual property rights only means patents. However, there are certain things which need to be clarified here, that IPR doesn't only mean patents. There are certain branches under which different intellectual property and different intellectual subject matter are being registered. So as far as the intellectual property rights are concerned, it's necessarily a result of human creation or human creativity. And that creativity may be in different forms. That may be in the industrial field, that may be in some intellectual, or that may be in the film or literary field, in dramatic field, or musical field, or any other field. So basically, when we talk of intellectual property rights, it's a collective, it's a bundle of rights having different type of intellectual properties. So there are at most 7 intellectual property rights which are presently registered in India, and they will include, apart from patent, we have copyright, we have designs, then we have geographical indications, we have semiconductor integrated circuits and layouts designs, then plant farmers bidders rights are there, and of course copyright along with trade secrets. So there are different sort of intellectual property rights. Right now, we will be focusing only on patents, and as I promised, sir, that we will surely conduct a lecture wherein different types of intellectual property we will be covering. That may be how not only patent, but how copyright, geographical indication, trademarks, then industrial designs, and other intellectual properties are governed. So we will be starting with intellectual property rights is nothing but the result of human creativity, whatever human brain thinks of, and that brain acts in that manner and creates different things which are not only useful to him but also to the society. So that takes different shape. It may be writing of a book, and that takes the form of copyright. It may be a shape of design, or shape or a design of an article that takes the form of industrial designs. Similarly, when we talk of patents, when it comes to inventions, patents comes into picture. And also geographical indications, the government, the India's valuable treasures are governed under the Geographical Indications Act. Then there are semiconductor integrated circuits. They are covered under the Semiconductor Integrated Circuits Layouts and Designs Act. So different types of intellectual properties are there. But right now we will be focusing on patent, as it's my domain. So we will be going ahead with what are patents. As far as patents are concerned, there are different myths. First, getting a patent is very difficult thing. Another issue is that getting patent is a very costly affair, and also needs lot of expertise. Then we need a lot of help from patent attorneys. So all there are certain misconceptions. So that misconceptions, and all the things we will be clearing here right now. And if it's my genuine and humble request, if you have any questions, ask me at that point, or you can ask me at the end of the session also. So when we talk of patents, what is patents? We hear the word patents. Many times you blindly say, "अरे इसका तो ये patented word है, याचा तर हा patented word आहे, हा नेहमी याचा हा patented dialogue आहे." What are these things? We just blindly say. But has anybody thought what is patent known in Hindi or Marathi? Can anybody tell me? Okay, so when I say patents, I mean to say patents in Hindi or Marathi is known as ekaswa. Ekaswa means only one person's right. Ek ka adhikar. The person who creates that thing will get the right, will get the monopoly. So basically, patents in Hindi or Marathi are known as ekaswa. Keep in mind that thing. So next time, whenever you talk of patent, you should understand you are talking in Marathi or Hindi. You should be able to say that ekaswa ki baat kar rahe hai hum. Ekaswa means only one person, the person who is the creator. So coming to patents. So mind you, keep this slide very important. Understand this slide. Once you understand this slide, almost half of your doubts will be cleared. So what is patent? Patent is an intellectual property right relating to inventions. So main thing I am focusing is on inventions. I am talking of inventions. So whenever you are thinking of filing a patent or getting a patent, you should understand patents are granted for inventions. Okay. And that inventions may be related to product or process. Then it is a exclusive monopoly right granted to the inventor by the government to use the patented invention for a limited period of time, that is 20 years, thus preventing others from making, using, importing, or selling in exchange of full disclosure of his invention. Now, here what happens? First of all, patents, the basic requirement, the thumb rule is that for patents, you need to have an invention, right? You need to have an invention. So whenever you are having an invention, you will be getting a patent. And that invention may be related to product or process. Either it should be a product or it should be a process. Then it's an exclusive monopoly right. What is that? Once you get the patent, you get an exclusive monopoly right. That means you will be the only person who is going to use this invention, and for a period of limited time period. That is, period is 20 years. So once you get the monopoly, you will be using this patent for a period of 20 years. And during this period, you will stop making others, or as you will stop using them. Here you can assign the patents to somebody, you can license it to somebody, you can sell. But what happens? In exchange of full disclosure of his invention. When I say in exchange of full disclosure of invention, I mean to say that once you file the application with government or patent office, ultimately it's a government office, so the invention is disclosed to government, and then the critical procedure of analysis or examination of patent application is being conducted with our patent office. And once you get the patent, then you get a monopoly for a period of 20 years. But what happens after the monopoly period is over? Then once the monopoly period is over, the invention falls in public domain, and then public starts using it freely. So the general theme is that government grants you the monopoly for your creative work that is related to invention, and you are being given the fruits of your invention which you have made in your field. So government grants you the monopoly. That means you get a right for 20 years, and during this period you are free to use this invention. But after the period is over, the invention falls in public domain, and then public can freely use it. This is the general theme of patent. So understand, patents are granted only for inventions. Now, the golden rule, which is followed not only in India but all over the world, that is basic requirements for getting a patent. So there are three golden rules that needs to be cleared for getting a patent. So that first rule is novelty, the another rule is inventive step, and third is industrial escape, industrial applicability. What are these things? We will see at later. First, understand invention under section 21J of Indian Patent Acts. When I say invention, what is invention? There is a basic theme, a basic difference between invention and discovery. What are these things? Because there are many misconceptions, like people are not aware of, and they come running with finding somebody. Somebody right now came to me, and in last 6 months, one person came to me and he said he found some stones in one area while digging that area in his farm, and he found some stones. So he said, I am the person, I have found these stones, and now I want a patent on that. So whether we consider it as discovery, or that time we have to politely say, no, sir, this is not an invention, this is a discovery. Discovery in the sense, something which is already present and you find it out. So the conception of invention should be very clear. The concept of invention means the new product or process involving inventive step and capable of industrial application. So when I say discovery, what is discovery? You should clearly mark the differences between discovery and invention. So discovery is something, the act of detecting something new or something old that has been not known. Something was already present in nature and somebody accidentally finds it out, is nothing but the discovery. But when we talk of invention, invention is something which is a result of human intervention. Lot of laboratory experiments, lot of trials, lot of experimentation, trial laboratory tests have been conducted. lot of labor work has been done, a lot of manpower has been used, a lot of things are required. Human intervention is basically required to get the invention. But when we talk of discovery, just the person, for example, when Christopher Columbus was traveling to some part of the world, he found a community of people staying in that area, and these people were nothing but the Americans. So he discovered America. So in simple word, discovery means to be the first, or to find, or to first to observe. That may be a place, substance, or any scientific phenomena. Just falling of an apple, that was the Newton's law, that gravity. So when it was, the apple was falling, it was the person who found, was just Newton was the first person to observe that, and therefore he pointed out that, but that is not an invention, that is a discovery. But an invention is creating something totally new with his known idea, owns ideas and development. For example, bulb was not existent in anywhere in nature. Thomas Edison invented it. Similarly, there are certain things which are like a bulb, telephone, wheel, computer. All these things are result of essentially human intervention. Lot of human brain, lot of laboratory experimentation trials have been conducted to arrive there. But whereas when we talk of instance theory of relativity, or concept of black hole in outer space, or Columbus discovered, or Vasco da Gama discovered India, all the examples are of discovery. Now, so basically, there are the things that needs to be understood. So the basic is you should come out with a invention and not a discovery. Now, I told you there are 3 rules. Now we will be dealing with the rules that are being applied while getting a patent, that is novelty, inventive step, and industrial applicability. Sir, I hope I am audible and visible also, right? Everything is clearly going on. Hello?
Yes, sir. Yes,
Yes,
sir.
sir.
It is clear. Clear.
Okay. So whenever if you find anything, you just point me out at that instance, right? So
Okay, sir. Okay.
now the concept of invention is clear. Why I am focusing on this aspect is because this is the basic requirement for getting a patent. Now there are Professor Kanse comes to me, Thakur sir, you have told me that for getting a patent you should come out with an invention. And at that time, I have to politely say, and grant me a patent. Dr. Kanse says that grant me a patent on that invention. So at that time, I have to politely say, sir, we should have not only have an invention, but the invention should have 3 aspects. That is the golden rules: novelty, inventive step, and industrial applicability. So what are these things? So an invention is considered to be novel. Means novelty means something new. If it does not form a part of state of the art. What do I mean by saying that? Novelty is nothing but the invention should be totally new. It should not be copied work. It should not be a Xerox copy, or it should not be replica of some person's copied work. You cannot come and copy and just say, "Kia, this is my invention." No, mind you, we patent office has a dedicated team of examiners who can easily find out whether this invention is copied or not, or whether it is taken from which part of the world, or which part of the country, or which part of the document. It can be easily traced because patent offices have a set of examiners who are the persons who are capable of conducting thorough search. We have databases, we have databases for non-patented literature as well as scientific literature. So all the documents, all the search tools are present with the patent office. And mind you cannot copy and come and say, this is my invention. One can easily trace, patent office can easily find out whether the invention is new or not. So basically, the invention novelty means it should be totally new. It should not form the state of the art. What is that? We will see. So when I say novelty means totally new. So novelty means if the invention has not been disclosed in any prior art before the priority date. So mind you, there is one term that is the priority date. So the basic theme of getting a patent is the priority date. Means the person who comes to patent office and files the application with the patent office gets the priority date. The date on which you file the application is nothing but the priority date. And from that date up, once the date is fixed or once the priority date is given, any document or anything which is published after this priority date will not be taken for assessing novelty of the invention or assessing inventive step of the invention. So basically any prior art which is before the priority date will only be considered as a relevant cited prior art. Now what is that? For example, anything which is published before that date will be considered as a anticipating document. So any invention is not novel if it has been anticipated having regard to public knowledge, well-known art or commonly used art, oral or otherwise available within the local or indigenous community in India or elsewhere. So when I say, what I mean to say is, for example, if your hand is cut or your finger is cut, immediately our old people, maybe your father, mother, grandmother, or any other old person, what does they say? They say apply turmeric. So what is that? That is nothing but the local or indigenous knowledge which is already available with our old community or old people. And they say, ki, nahi, just simply apply turmeric, haldi laga lo, it will be clear. So nothing that, so that is nothing but the anticipation, or that is the public knowledge which is there. So basically, certain things are taken into consideration while judging the novelty. So prior art, what is that prior art? We will see. Then novelty is determined before the inventive step, because the creative contribution of inventor can be assessed only by knowing the novel elements of the invention. So stepwise examination of patent application takes place. First, we see whether there is an invention. Then we see whether the invention is new. It is not published anywhere. It is not copied. So whenever we come across the word prior art, we basically many times, many persons say that please conduct a prior art search. We humbly request all the inventors, all the persons, or wherever we go for lecture, please search for the prior art documents. That prior art documents are nothing but the written or any printed publications, books, then journals, articles, theses, manuscript, then any published patents, any published designs, etc. Then oral presentations, meetings, communications, then even in prototypes or in samples is there, or any public use is there. You can just see whether all these prior art, whether before making, see, getting patent is of course, requires lot of cost. So it's always better to conduct a prior art search. So what are these documents for assessing knowledge, novelty is nothing but the publications, journals, all these documents are taken while considering the prior art. So once you think of filing a patent application, it's a humble request you conduct a prior art search before filing any document or before proceeding with any idea or before proceeding with any invention, because you spend a lot of time coming to that, and once you get once it comes to patent office simply cites one document, see sir, this is already in public domain and now your invention is lacking novelty. So all the efforts become futile. Not only efforts, money, time, everything is being wasted. So it's humble request that you conduct a prior art search before filing a patent application. So these are the documents which we take into consideration while assessing novelty of an application. Then publication. Already publication in any prior document, including the patent specification. So for example, we will see later a document containing a diagram or article or a cartoon. Even single document, and only single document is required to destroy the novelty of the publication or the invention. What is that single document? Let us see. There was one case wherein a doorbell case, just a landmark case. This invention for a doorbell was filed with the patent office, and the inventions claimed that it was a doorbell fixed at the bottom of the door and which was to be used by dogs to alert the master on his arrival. So once the bell was there and it was fixed at the bottom of the door and it was to be used by dogs, dog used to press that bell and indicate that the master has arrived. Now, this invention, while examiner finds a cartoon. There was one cartoon depicting a dog opening the door with his nose using the doorbell fixed at the bottom of the door. And this cartoon was published in a newspaper prior to the date of filing of the patent application. So what happened when the examiner found this sort of document already published on a cartoon box or on a newspaper was published document, and the date on which this newspaper was published was prior to the date of filing of the patent application. Therefore, it was before the priority date, and then the examiner has nothing. Then he simply said that the inventions lack novelty, and therefore he rejected the application. So mind you, priority date is very important. Invention is required to be done. It should be totally new. It should not be published in any of these sort of publication. One, then it should not be in prior use. That public means public should not be able to use that thing. Public should be not aware of whatever the things are. Like I told you, the use of turmeric. So it is already in public domain. Now, what 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 are the things? Then of course public knowledge already there. All public knowledge that is published is taken into consideration. Then traditional knowledge, I told you, turmeric. So all these documents which are in public domain are considered prior art documents, and they are very useful, or they are considered while judging the novelty of a inventive story. Now, there are certain exceptions under which we can say that the invention is not anticipated. For example, if it is published in pursuance of the application filed before 1 month 12. So, if the document is filed or the citation is published before the date of 1/1/1912, then we will not touch that document. Then obtained from the applicant but published without his consent. Suppose Dr. Ballard's invention is been copied by some other person and he publishes it without his knowledge, then if Dr. Ballard complains, sir, this is already in my invention, and then that also will not be considered as anticipation. Then if you communicate it to government for investigation purpose, it will not be treated as. But displayed, exhibit, used with the concept of inventor at the industrial or other exhibitions notified by government, or accidental use is not taken as prior use. So prior use also is taken into consideration, but there are certain exceptions where we see that here prior use cannot be considered for getting or destroying a novelty. Now, what is the test for novelty? What is the scope and the content of the prior art? Then we conduct differences between the claims and the prior art. For novelty, all the features from the independent claim should be described in a single document. In other words, prior publication or activity must contain the whole of the impunged invention, clear instructions, illustrations, or unmistakable direction necessary. So by just going through this document, you should be able to understand, or you can just say that it is a copy of a earlier invention, or the invention which is filed for examination for is just a copy or replica, or it is a simple Xerox copy of the invention which is being filed. So at that time, we will say that the invention is lacking novelty. Then one important question which comes to us as far as university professors, lecturers, or research associate is concerned, that is related to research paper. See, earlier the concept was either publish or perish. So in that hurry, all the people, research people, that may be professors, we come across many IIT professors or IIT, not only IIT, but from also reputed colleges, who come to patent office by saying, sir, this invention is there. But which we have published in some research paper or in a reputed journal. And then what happens here? Suppose a person makes an invention and he just simply published it with in a reputed journal, that is the Learned Society or any other reputed journal. And once the invention or the paper is published, then some renowned person or some senior person reads that in paper and says, have you filed an application for patent? And at that time he says, no, I have not filed any application for patent, but I was in hurry to publish my patent. I was in a hurry to publish my paper. But then that professor says, Ki, why don't you try for a patent? And at that time, all these people, all these research scholars or the professors come to patent office and file an application. And mind you, this application or these research papers can be easily traced. We have a dedicated search databases wherein we can easily find out. Now in Google also you can easily find out whether this invention is published or not, or whether this sort of public, just putting the keywords, you can easily find out whether this sort of paper was published. And then they come, they just, at that time we are also helpless, we cannot help them, we are not able to help them because that already invention is already, or that the paper is already in public domain, and then they lose their novelty, and ultimately the blockbuster product or process which they have invented goes in public domain without getting any benefit. So it's a humble request, or the concept now used is first file an application for patent, then go in for publication, and then go in for commercialization. So here only one excuse is been given to the research paper publishers, that if the research paper is published in a renowned society or with the consent of inventors in transaction of such society, then within a period of 12 months, if he comes and files invention, we grant, we do not consider this as a novelty destroying document. But here we say that yes, the benefit of doubt is given to the applicant or the inventor who invents this thing. But after 12 months, your document itself becomes a novelty destroying document, and that time nobody will be able to help you, not even patent office, nobody will be able to help you, because you are already lost your novelty of the invention or of the paper, research work which you have carried out. So the basic theme is that you, whatever invention or whatever research works you carry out, first file an application with patent office, and then go ahead with whatever publication or whatever use you want to make. So that is related to novelty. So I suppose novelty is clear with you. Any doubts with regard to novelty, you can ask me right now, or we can consider it at the latter part of the session, right? So in simple words, the novel invention should be new. It should not be known to somebody else, or it should not be known at the date of filing of the application. Once the novelty is judged, then the another phase comes up, that is the inventive step. What is that inventive step? The invention must not only be novel, but also have a substantial and significant difference with regard to state of art. What is that? So when we talk of inventive feature, inventive step means a feature of an invention that involves technological advancement as compared to existing knowledge, or having economic significance, or both, and that makes the invention not obvious to a person skilled in the art. So there are, the technical definition of inventive step clearly mentions there are two things that are required. Just read in terms of law. There should be technical advance as compared to existing knowledge. First requirement is that there should be technological advancement as compared to existing knowledge. Whatever existing knowledge was there, there should be some technical advancement. Or another aspect is there is a economic significance, or both, and that makes the invention not obvious to a person skilled in the art. So the invention clearly, inventive step clearly defines there should be technical advancement. Now, what is technical advancement? Let us take for an example. Earlier, we used to use, our forefathers or grandfathers used to listen music on gramophone records, right? Then eventually a phase came of tape recorder. That means you start using the cassette player, right? Then came the version of CD, then VCD. Now you are using a pen drive which is having almost 1 TB data. So these are the technological advancement. That is the technical advancement which has happened in the musical field. Similarly, earlier when the mobile phones were launched, we were using a 2G spectrums. Then eventually we moved on to 3G spectrum, 4G spectrum. Now we are entering the 5G spectrum, while China is already ahead, they are already in 6G spectrum. So this is what the technological advancement as compared to existing knowledge. So there is a technical advancement. Earlier, we also had that big Dabba TVs, black and white TVs. Then eventually color TV came, then plasma, then LCD, then LED, now OLED. So all this is nothing but the technical advancement over the existing knowledge. Earlier we had that black and white mobile phones. Now we have come to the smartphone. So different types of these inventions or different types of advancement is nothing but the technical advancement over the existing knowledge. So is that clear with you? Now, having regard to economic significance. Now, what is economic significance? Suppose an article was available in market for a price of ₹1,000, but Dr. Ballard comes with the same product with a price of only 200 rupees. Yes, the cost has been drastically reduced from 1,000 rupees to $200. So that is nothing but the economic significance. As far as now pharmacy persons are concerned, we can see in terms of pharmacy or in terms of paracetamol or in terms of pharmaceutical inventions. What is that? Suppose a person was requiring a dose of azithromycin 500 mg for 5 days. This was the dose which we are using. But Dr. Balla finds out same azithromycin with a process or something, or comes out with some economically significant, that instead of 500 mg dose, he makes the dose of only 100 mg, and not for 5 days, but only for 2 days. Yes, we can say yes, there is a significance, economic significance. Yes, ultimately there is a cost reduction. Instead of 500 mg dose, we are giving you 100 mg dose, not for 5 days, but for only 2 days or 3 days. So that we can point out it as a economic significance. So for getting clearing the inventive step, we should understand there should be first, that is technical advancement. Of course, there should be some problem, and that problem should be addressed by that invention. So there is a technical advancement or economic significance. So either technical advancement is required or economic significance, or even if both are present, that is also well and good, and that makes the invention not obvious to person skilled in the art. Means you should not be used. Suppose you are aware of halogen, that means chlorine, bromine, all these things. So if there is an invention related with chlorine, it's very obvious for a person skilled in the art is the person who works with that kind of field, in the same field. Suppose a person skilled in the art in pharmaceutical invention is a pharmacist, so he can easily understand instead of chlorine we can use bromine. So that concept or that should not be very obvious. Instead of sodium we should not use potassium salts. So this type of salts or this type of things which are a very obvious combination should not be considered. So basically the main theme is there should be technical advancement and there should be a economic significance. So this is the theme of inventive step. So now here, how the inventive step is judged by the patent office. Now this is a person, this we call it as a POSA also, that is person skilled in the art, person ordinary skill in the art, that is POSA. Now he is the person, or here in this term, here is the examiner or the controller of patents who is looking at the invention. Now what is the prior art? What was the prior art? Then what was the common general knowledge that is very well available in the market or very well aware of, people are aware of? And then invention, your invention, what is that? Then the person skill in the art, that means a person skill in the art arrive at the invention by following his or his logical rational reasoning. So there are certain countries, every country has different procedure for judging an inventive step, but the main theme is that there should be a problem and there should be a solution. Some problem solution approach should be there, so that the invention is fruitful, or invention is having a technical advancement, or it is having a economic significance. It should solve some problem. So basically the theme is that it should solve some problem which was there, and that is nothing but the inventive step. So once you clear your novelty aspect and once you clear out your inventive aspect, then we proceed with the third aspect. Now See, in simple words, if you see what is the problem, what was the problem associated with the prior art, then what is the problem solution approach, what was the problem, what is the problem solution approach that is being applied in the claimed invention, and then what is the common general knowledge which is available in readily available in public domain, and determine the relevance of these citations, and then you can easily access whether that invention is obvious or it is not obvious. So it is inventive or it is not it is having a inventive step or not. So mind you, when I talk of novelty in US or in other countries, it is also synonymally named as anticipation. But when we talk of inventive step, also in US and other countries, many other countries, they call it as obviousness, test of obviousness. We called it as inventive step. But they are the synonyms and parallelly used in different countries in different ways. So what was the problem? What was the solution? What was the common general knowledge? And then applying the rationale, the person skill in the art obviously judges whether the invention is obvious or not. So this is the inventive step analysis while in India we conduct. For example, we will take a simple example. Now here, since I was told that there are pharmacy students or chemistry students or pharmacy students, so I had taken one example wherein we can just see how the patent office analyzes the inventive step. Now the invention was that the compound represented by formula PYB3, in which PY stands for specific pyrrolizone skeleton and B3 stands for ethyl. The compounds of the invention possesses analgesic property. This is the invention which is claimed. Now the examiner conducts a prior art search and he finds out the closest document is PYB3. He finds out again PYB3, wherein B stands for methyl, right? Here B stands for ethyl. So methyl, the combination, the compound of the prior art not known to possess any therapeutic activity. Here he says the compound of the prior art was not known to possess any therapeutic activity. Now what happened? See, the basic prior art was PYB3. This is the invention, which is the compound which has been claimed. Now, wherein it was clearly the person has, the examiner or the controller has pointed out this was the cited document. Now, and simply here methyl was replaced by ethyl, right? Here the claimed invention. Now, how the analysis took place? Now, the identifying the concept. The inventive concept in PYB3 stands that for ethyl, whereas the compounds of invention possess analgesic property. So this is the effect which was found. Now, inputting to an ordinary person's skill in the art, having ordinary creative, what was the common general? The test required two activities, namely identifying the skilled person and the common general knowledge. Now here the skilled person is a medicinal chemist or a pharmacologist or an organochemist, right? Now what is the common general knowledge? That is the citation which has been cited. So the skilled person has a thoroughly knowledge of pyrrolizones and the compounds which are having these things. Now he has pointed out the differences. What differences? The difference between the prior art and the invention is the replacement of 3-methyl substituent at the annual position and pharmaceutical activity of the resultant compound. What was the prior art saying? Now, the prior art was, although very structurally similar, but does not provide any clue to the skilled person to resultant compound, that a very nominal change would be successful as a pharmaceutical product. Just changing from methyl to ethyl would have been obvious for a person skilled in the art, but the change would not achieving any pharmacological activity of the modified compound. In other words, there is no coherent thread leading from the prior art to arrive at the invention. Alternatively, it was said that there is no prior art motivation, and therefore we considered it as a non-obvious. Simply here, understand the common general knowledge was that it is not having any property, was not known. But just by movement of this from methyl to ethyl, it was found that the compound possesses analgesic property. So it was not accidental, it was a result of uh, technological advancement which he made in the invention. Therefore, we considered it as a inventive part. Then that is what we relate to inventive concept. Presently, you understand that there are two elements while judging for inventive step. What is the technological advancement, or what is the economic significance, or both of them are required. Then the third aspect is industrial application. Means invention should be capable of being used, or yes, used in any industry. What does that mean? Means you should not be able to use that invention in n number of forms. You should be able to produce that number in n number of quantity, so that the reasonable requirement of public at large is satisfied. What do I mean by saying that? You should not block the technology. Dr. Balla gets a patent for an invention, and now he says, I will not give it to anybody. I will restrict it. I will take the monopoly. I will keep the monopoly for me for a period of 20 years. I will not disclose it to any other person, or I will not give that invention to anybody. No, this will not be permitted, because there are certain criteria under industrial applicability. Means you should be able to produce that invention in n number of quantities, so that the reasonable requirement of public at large is satisfied. So you should necessarily solve the reasonable requirement of public. You should, if a person invents a mobile phone and he says, I will restrict it to myself, I will not give it to anybody, this will not be permitted. This has happened in case of Remdesivir and any other injections which were very popular in the COVID phase. So we will not go in much detail. But these are the three golden rules. Mind you, there should be novelty, there should be industrial applicability, and there should be inventive step. So when I say novelty, please understand that the invention should be new. It should not be copied work. It should not be replica, or it should not be Xerox copy of some other person's work. When I say inventive step, there should be technical advancement with a reference to existing knowledge, or there should be economic significance. When I say industrial application or industrial applicability, I mean to see that the invention is capable of being used in industry, right? So this is the thumb rule. So whenever the application comes for examination in patent office, we have a dedicated team of examiners. I told you, if the invention belongs to mechanical field, mechanical engineering department is there. If it is coming to pharmacy division, pharmaceutical invention, we have pharmacy division there. We have chemical department there. Biotechnology inventions are referred to biotechnology persons. Then similarly, electronics engineering, computer engineering, all we have dedicated teams of examiners and dedicated teams of controller who, when the subject is related, the subject is given to that specific person. Now, I told you there is a requirement of invention, no requirement of novelty, requirement of inventive step, requirement of industrial applicability. Okay, even of all these criteria are satisfied, then you Dr. Balla will say, now we grant me patent. So I will say, yes, sir, I will definitely grant, but it does not fall under the domain of inventions, not patentable inventions under Section 3 and Section 4 of the Act. So there are certain exceptions under these conditions. In India, we cannot grant patents. What are these conditions? We will see. Okay. So when there is a Section 3 which talks that certain inventions, even though they are inventions, we will not consider it as invention. Suppose a frivolous invention or inventions contrary to well-established natural law. For somebody makes a machine and he says that it gives more than 100% performance, we will say it is a frivolous invention. It is a fake invention. It will not. It is practically not possible. Then perpetual machine. If somebody says I have made a perpetual machine is moving on the basis of wind. So as such, it is contrary to the well-established natural law. Then we can say yes, no, this is not a patentable invention. Then this is, mind you, very important. Primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health or to the environment. When I say this, I mean to say Somebody comes and says, "Ki I have made a gambling machine, or I have made a device for housebreaking." We will say the commercial or the intended use is against the public order, it's against the public morality. Suppose somebody says, "I am making a bomb," then or a procedure or a material which is biological warfare material. For example, somebody comes, I say, "Coronavirus bana raha hu," so we will not give. This is against the public order or morality. Similarly, oncomouse case, then embryonic stem cell, the Terminator gene technology, all these technologies which are against uh, public morality and which causes serious prejudice to human, animal, or plant life will not be granted patent, right? Then mere discovery of scientific principle. I told you that discovery, somebody says, "Ki I have found a metal, or I have found a microorganism, or I have found something, I have found some natural gas or some mineral." Then we will say, "Ki this is not an invention, this is a discovery." Mind you, discoveries are barred from getting a patent. Then section 3D, which is very important as far as pharmaceutical chemistry is concerned. The mere discovery of a new form of a known substance, mere discovery of a new form of a known substance which does not result in the enhancement of known efficacy of that substance, or the mere discovery of any new property or new use of a known substance. For example, you see, there was a famous case of imatinib toisolate, wherein this is nothing but the evergreening effect or evergreening of the already patented molecule. What happens here? Suppose penicillin, sodium penicillin is being patented, and the invention is being given monopoly for Hindustan Antibiotics. Then Hindustan Antibiotics is taking monopoly for 20 years, and they are only sodium penicillin is being sold by them. But before the patent term expires, what they cleverly do, instead of uh, sodium penicillin, they come out with potassium penicillin, and just make a salt of that thing. So that salts, that may be salts, ether, polymorphs, metabolites, pure forms, particle size, isomers, mixtures of isomers, complexes, or combination. So the mere discovery of a new form of a known substance which does not result in enhancement of known efficacy. That means the compound is safe, and if you are making any salts, then we will say nothing. This is an attempt to evergreen the patent already which is existence, and that before that invention goes in public domain, they want to claim another monopoly. So at such sort of inventions are also not patentable. Then inventions just mere admixtures resulting only in the aggregation of properties of components thereof, or process for producing such substances. For example, a paracetamol is known as antipyretic, but and brufen also is known as analgesic. And you produce a drug that may be any combination of paracetamol with brufen, that is antipyretic and analgesic. We have already aware of that paracetamol is used to reduce the temperature of body. That means it is antipyretic, and brufen is as used as a painkiller, or instead of brufen, diclofenac is used. That is again a painkiller. So we know that the effect will be the same. But if this drug, instead of using it analgesic or pending, if it is used in the treatment of cancer, or it is somebody finds out that it is used in the treatment of cancer, or it is used in the treatment of corona, then we can say yes, this is not a mere admixture, but in this case it is a simple admixture. Similarly, a mixture of sugar or some colorant in water to produce a soft drink is mere admixture. So mere admixtures should not be considered as an invention. They should necessarily show synergistic effect, and that synergistic effect is considered while judging the invention, whether it is falling as a admixture or not. Then mere arrangement or rearrangement of duplication of known devices, each functioning independently of one another in a known way. Section 3F. What does section 3F says? We generally call these as jugaad patents. Jugaad patents. What are the jugaad patents? Suppose a person, you might be seeing various clips that are going on WhatsApp, or that may be on Facebook or some other social media, that a person is using a bucket fitted with a torch, Obviously, the bucket is used to carry water and the torch is used to give a light. So both are functioning independently of one another. There is no correlations. There is no coherence. There is no coring effect. The bucket is having different function. The torch is having different function, and they are functioning independently. So that sort of mere arrangement or rearrangement is also not permissible. Then a person comes with an umbrella with a fan, or a clock and radio in a single cabinet, or the floor mill provided with sieving. So all these things are nothing but the mere arrangement or rearrangement of the known devices or duplication. So they are also barred from getting a pay. Then very important is method of agriculture or horticulture. As you are aware of that India is a agriculture country or kisan pradhan desh hai, so we are not giving any inventions which are related to method of agriculture or horticulture. However, the instrument which can be used and which are useful in the agricultures can be are patentable, so they can be granted patent provided the clear the test of novelty, inventive step and industrial applicability. So method of agriculture or horticulture itself is not patentable. However, equipments which are useful in agriculture are patentable. Then again, section 3I, which is also important from pharmacy point of view. Any process for medical, medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings or a similar treatment of animals to render them free of disease or to increase their value, economic value, or their products cannot be considered as a method or considered as a patentable issue. Why? Because see, now if you are conducting an angiography, it's hardly the doctors are charging 5,000 to 7,000 or 8,000, at the most 10,000 rupees. But if a monopoly is given for method of treatment or method of doing angiography or method of doing angioplasty or bypass surgery or any related treatment, mind you, if they get a monopoly, they will start charging exorbitant amount of money, and such sort of treatment in any field that may be in the medicine, surgical, curative, prophylactic, diagnostic, or therapeutic, or other treatment of human beings is not patentable in India, right? Then section 3J, plants and animals in whole or any part thereof, other than microorganisms. When other than microorganisms, I mean to say genetically modified microorganism can be patented, but as such appearing in nature are not patentable. But genetically modified microorganism you create, they are patentable. Plants and animals as such in whole or their seeds or any other part is also not patentable under the section 3J of that. Then 3K is mathematical or business method or a computer program per se or algorithms. So even if you make a computer program or algorithm, that itself cannot be considered as a patentable invention. However, combining a software and hardware is patentable. So if you come across computer program per se, it's a matter of copyright. It's not a matter of patent. So again, they are barred from getting a patent. Then 3L, the literary, dramatic, musical or artistic work or any aesthetic creation, including cinematographic and televisionic product. All these things fall under the copyright protection and they are not considered as inventions under section 3L. Then 3M, mere scheme or rule or method of performing any mental act or method of playing a game. For example, you see method of playing a game, that is you see Kaun Banega Crorepati right now, which is going. The method cannot be patented. However, the instrument which they have made, if they are, it is a novel instrument, then that can be considered as a patentable subject. Then 3N, any method of information, a way of expression, spoken word, visual, symbols, diagram. Any person who tries to mode of expression will not be considered as a then topography of integrated circuits. Again, and they pertain to the inventions which fall under the SCILD Act, that is Semiconductor Integrated Circuits Layout and Designs Act. So they are getting protection under that category, not here. Then 3P, again, the inventions which are traditional knowledge or an aggregation or duplication of known properties of traditionally known components are not patentable. For example, wound healing property of haldi. You might be aware of that is turmeric case, neem case, and then basmati case. All these things are nothing but the traditionally owned compounds or traditionally knowledge. And what has happened with the these patents that were being claimed, and then India has to fight a big battle to get the patent over revoked from these countries, US and Europe. So we traditional knowledge is also not considered as patentable invention. Then inventions which are falling under section 21 of the Atomic Energy Act are not patentable. For example, inventions which are radioactive elements, uranium, beryllium, or thorium or plutonium, radium, all these elements, inventions relating to them are not considered patentable. However, once we get a clearance from Department of Atomic Energy, then we, if they say that invention is not threat to Indian security or that can be patented, then we go ahead with the inventions that is falling under Section 4. So, mind you, these are the exceptions wherein we can say, ki, uh, uh, this is how the patent theme is there. I suppose, can we continue or we should stop, sir?
Uh, Actually,
Hello?
sir, the institution has scheduled the staff meeting at
Okay.
1:15. That's what. Yeah, yeah,
Okay.
yeah,
So,
yeah, yeah.
okay. So, what we can do is we will stop at this point because basically, when I was going to discuss the process, also how the process of patenting takes place, how the work is
Okay, okay.
conducted. But right now, before going into that detail, one should understand the basics of patents. So right now, I suppose we should stop here because it's already 12:50. And if you want, we can arrange another lecture when the procedural aspects will be dealt. But as far as this part is concerned, I want the thorough basic of patents to be cleared from all these persons who are appearing for this session. So I suppose once you clear all these basic hurdles, that is, once you clear the invention, novelty, inventive, industrial aircraft, section 3 and section 4, then you can go ahead with patents. Nobody can stop you from getting a patent in this course, right?
Sir, it's a
Thank
sort
you,
of
sir.
Dhananjay sir, 1 minute. It's a sort of
Okay.
confession from our side, Thakur sir,
Mhm.
that almost 21 sessions we have organized regarding the intellectual property rights, and every session was lacking the clarity. And this time we find that clarity from your side. Just it is not a formality. It is not a formality statement. From really from heart, you projected every complex aspect of the intellectual property in very simple manner. So special thanks from the IPR committee. So, Dhanavade sir, you can take the charge.
Thank,
Yeah.
thank you, sir, for enlightening us with this nice information. I'm sure that most of the researchers are now know that how to protect their intellectual property and use their intellectual property rights for the benefit of themselves and society. Now I hand over the session towards Dr. Mrs. Varsha Kumbar Madam to give vote of thanks. Dr. Varsha Kumbar Madam.
Sir,
Thank you, sir.
just I will take 2 minutes. If there are any questions or if there are any doubts, you can write to me or you can write to Dr. Ballar sir. He will definitely send these
Yeah, yeah.
queries to
I
me.
will
We will
forward
come
all
to address.
questions to sir. Yeah, yeah,
Yes, sir, sure, sir.
yes, sir.
Okay, then
Thank you,
continue.
sir. Am I audible?
Yes, yes.
Yes, you are audible.
Yeah.
Thank you, sir. Good afternoon, everyone, to the one and all present here. Honorable Chief Guest Dr. Ajay Thakur, sir, Assistant Controller of Patent and Design, Government of India, Mumbai. Respected Principal of College, Dr. D.G. Kanse, sir, Arts and Commerce in charge, Mr. T.R. Sawant, sir, and all the participants. It is such an honor for me to get the opportunity to thank you all. dignitaries, on the behalf of the IPR cell of Bharati Vidyapeeth's Dr. Patangrao Kadam Mahavidyalaya, Sangli. I would like to express my gratitude to our Honorable Chief Guest and Speaker, Dr. Ajay Thakur Sir, Assistant Controller of Patents and Design, Government of India, Mumbai, to take out time from his busy schedule to grace the event. Thank you, sir, for inspiring and encouraging us with your words. A special thanks to our principal and chairman of this webinar, Honorable Dr. D.G. Concessor, for providing immense support to make the webinar successful. I extend my gratitude to convener of IPR Sir, Dr. B.B. Balla sir, to organize such an informative webinar. I am very much thankful to Mr. Amol Vande sir for his technical support, Dr. Maruti Ganade for his nice anchoring of the program, and all the members of organizing team of the IPRC. I am happy to express vote of thanks to Arts and Commerce in charge, Mr. T.R. Sawant sir, and all the faculty members of our college who have made this webinar a great success. At the end, I would like to express my gratitude to all the esteemed delegates of the webinar for their presence and contribution to make this webinar a great success. If the time is money, then today you all have spent millions for us. Thank you to all of you for making this event successful. With the prior permission of chairman, I hereby declare the program is over. Thank you one and all.
Thank you.
Thank you, sir. Thank you all attendees for giving us an opportunity. Thank you.